Whenever you're in property management, you realize that there's no one source of regulations. Every governmental agency, every government level seems to want to get into a portion of your business. You've got cities, counties, state, federal. You've got organizations created by counties like Bay Area Air Quality Management District, and every level seems to have lots and lots of people to write lots and lots of regulations. So you come up with the Civil Code, Code of Civil Procedures, Health and Safety Code, Fire Codes, etc., and you're expected to comply with all of them. Even if you are in full compliance, or you feel you're in full compliance, you may not be. There's an item that in recent years is called disparate impact. That's where an action that you take actually has an effect on one of the protected classes that you didn't intend, you didn't set out to violate their civil rights, but by statistics they can prove that you have violated their civil rights. The newest one that has been determined by HUD to be a disparate impact is the use of records, felon records, conviction records, to deny people housing. So if you are asking, were you convicted of a felony, and they answer yes, and you tell them no because of that, you're now breaking the law. You might wonder, how did they come up with that? Well, it turns out that the government incarcerates more minorities than they do the majorities. And consequently, if you're using their convictions against them, there are more minorities that are going to be affected. So you can still screen felons based upon your rental criteria, but whether they're convicted of a felony or not shouldn't be a deciding factor. If you use it as a deciding factor and one of the testers find out, the government will come out and fine you. And there have been property management companies that have been fined substantially. So carefully review your application criteria, and use only those things germane to that person